let's talk about maybe mom leaves her 30-06, maybe leaning on the nightstand. Okay, she has a specialized magazine. The magazine is fully loaded. Now, she thinks she's being safe. She checks it every night and makes sure there's not one in the chamber. Okay, and make sure that the safeties are on. All right, so now let's say that little Johnny grabs the gun, jacks the lever, takes aim, and launches the 165 grain bullet through the window at the neighbor's cat Precious.
Never did like that cat. She's negligent.
Okay.
Because the law says whether there's a round in the chamber or not.
That's exactly right. Okay, that's the point of that question. The point is not for me to say whether, as Trey pointed out, whether she was criminally negligent or not. That's going to be a jury question. But the point of that question is it was readily dischargeable. Okay, and readily dischargeable under this law doesn't mean loaded with ammunition, whether or not a round is in the chamber.
I sent you a secondary question to that. I don't want to get ahead of you. But what if you got the firearm, chamber's empty, magazine is out of the gun, and maybe it's not near the gun, maybe the homeowner's got it on their person, or maybe they put it in the drawer.
Okay, let's say mom has her Louis Vuitton purse. All right, she leaves it laying on the living room sofa, wide open. Okay, she's got her, let's say the Ruger LCR 38 Special laying right there, obviously where it can be seen in the purse. She's got the bullets right in the front pocket, also open, right? Little Johnny grabs the gun, loads it, okay, is all hopped up on Dr. Pepper and Sour Punch Kids, okay, and runs out shooting away, okay? Now what do we say?
Well, I want to attack that two different ways. It probably wasn't wise. If we want to, I want to get the legal thing, the legal part of it, and then the common sense part of it. I don't know if legally that would be categorized as a loaded weapon because it's readily available or whatever. But in the common sense aspect of it, absolutely, it was wrong.
Under the language of the statute, right, she's not guilty under 4613. Okay, because it was not readily dischargeable.
Right.
There was not ammunition in the weapon.
Now I want to clear something up because I'm not picking on you. I just want to make sure so I can understand the difference between the two. You made mention to a revolver, okay, and the cartridge is going into the cylinder. I'm talking about an auto pistol with the magazine out loaded. It's a much easier.
Same difference.
Concept. Okay.
In my opinion, same difference. You got the bullets outside the weapon.
Okay.
They're not in the weapon. Now, is that endangerment of a child, abandonment of a child? Are you going to be possibly in trouble for something else? Yeah, I mean, I'd say those are possibilities based on the factors of the case. Today we're limited right now to 4613. Like you said, common sense.
Well, heck, man, if you say it that way, I'd rather take the Class A.
I mean, I feel you. And so, I mean, you know, you gotta be smart though, okay? And like I said, there's probably some defenses maybe that I can make from the constitutional standpoint, construction standpoint, but you don't want to have to be hiring me to make those arguments.
That's right. Now, there's a difference between you screwed up one time, because everybody's human. We all screw up. But if your general practice is lackadaisical, that's the proper way to say it, right? And your methods of protecting your children and keeping guns away from them, and it's a constant problem where the stuff is all over the place for them to have access to, as compared to one time something happened, something fell over, the wife dropped the purse, and it happened to open up, and there was stuff there. Do you see the difference?
Yes.
So how does that looked upon in the court? It doesn't matter.
And that's what I'm saying. If that could be an issue. That's why you just need to make sure that you're in control of your weapon. You know what you're doing. It's in even if your weapon were to fall out, right? You would not have maybe. I mean, accidents happen, and accidents are going to happen. Guns or not, no guns, period. But that's why you just need to make sure, because you don't want to be in this situation where you're having to ask 12 people to decide some fact issue that they weren't there and try to convince them that that's really what happened. And I say really, it's supposed to be presumed beyond a reasonable doubt. I'm just telling you.
Before this segment's up, I want to discuss with you negligent and accidental discharges. There is a difference, and I think because you just brought something up, I want to talk about it because I've had both, and it's interesting. So I want to make sure we talk about that.
Well, let's say that Johnny and his dad go deer hunting, and the dad's going to show Johnny how to deer hunt, and so they go, and Dad hands Johnny the fully loaded 7 mag again, right to him. And then they go walking off in the woods side by side together. Okay? Dad sees an 18-point buck. He says, Johnny, bag him. Okay, Johnny points, pulls the trigger. Right? 180 grain bullets, way too much for Johnny. It kicks. Boom, you got the bullet selling fields across his Dick Cheney in the leg.
Mm-hmm.
Okay? Do we have a defense?
Do we have a defense or a prosecution?
Could he be charged? Well, he made a loaded firearm accessible to a child, and it was readily dischargeable.
But he was within his presence. It's not like the child had access to it without supervision.
Which is why we get in now to the distinction between, right, an affirmative defense and a defense. So if this was classified as a defense,
clarify that. I'm vague on those terms.
If the code were to say that it's a defense to prosecution that such and such set of events occurred, okay, then they probably couldn't charge you. It would probably be wrongful for the police to charge you. When it says you have an affirmative defense,
it's like no way out of that one.
It's like you can still be charged, arrested, indicted, right? In this case, the misdemeanor, so probably not talking about an indictment, okay, unless there's some other kind of factors that make it like something else criminal, okay, on an enhanced degree. But it's an affirmative defense. You're going to have to assert at trial. Okay. Now, would a DA probably do that because it's a waste of time? You'd be absolutely entitled to the affirmative defense. Okay, there was no other facts showing anything else, then you'd be entitled to win this case, right? Especially if Dick Cheney came to you and sued you for a civil suit that you were what we call negligent per se. This is right up Rick Dodd's alley. Okay, to say that you violated a criminal statute, therefore you're absolutely, as a matter of law, negligent. Well, he has a defense under that criminal law because right, he was supervising, he was over 18, and it was during a hunting activity. So, you have an affirmative defense if you're supervising the child and you're over 18 years of age and it's during a hunting, sporting, or other lawful activity.
Would it be considered negligent to allow a child a rifle with the inability to maintain and handle that rifle?
Oh man, do we have a lifeline for Rick?
Look, I tell you, I come from a family of attorneys, man. I'll take anything and spin it.
I mean, that's getting into the civil nature, and again, there may be something criminally that I don't know some inventive prosecutor can come up with in that.
Because I don't know any prosecutor who gets hired to lose. You know what I'm
saying? We're lawyers. I mean, we go for the. I'm not going to say what.
Everybody, the number here 254-697-6633. It's a good topic here. Give us a call. Give us examples. Stay anonymous. Whatever. But if you got a question, I'm sure there's 100 other people with the same question. So give us a call. 254-697-6633.
Let's go back to Maggie's 30-06 laying on the nightstand. Again, she double checks it. Right. So there's not one in the chamber, but she got this specialized magazine. There's bullets in the magazine, and she's got her safety on. Okay, Johnny hears somebody breaking in. Right, he runs to Maggie's bedroom, right, grabs the weapon, jacks the lever, and says, "Freeze, you son of a basketball coach!" You see Trey flinch right there. They almost kicked me off this show, folks. Anyway, so he gets the burglar. Burglar runs out, trips, falls. He gets arrested. After he gets arrested, he comes back, sues Maggie and her husband for emotional distress and claims for violation of this criminal statute, 4613. Can Maggie get the case dismissed?
Yes.
Why?
Because he was in protection of life and home.
Right. So it's another affirmative defense to this charge that the child, when he gained access to the weapon, is using the weapon in defense of people or property.
Let's jump it up a notch. It was out in the open to begin with. So the question of having access to it wasn't difficult. What if you have your guns tucked away, locked up, whatever, and then let's do two scenarios on this one. The guns are locked away. Mama's and daddy's not home. Child's home. It's okay for the child to be home at a certain particular age, but they're still under 18 years of age. And then they have to have access to the firearm to defend themselves. And then the other scenario would be parents are gone and the child gets the hairpin and unlocks the lock and has access to the gun.
Okay.
Two different scenarios.
So there's like we said, there's two elements to this thing about criminally negligent. Okay, so you're either criminally negligent in failing to secure the firearm, or you're criminally negligent in leaving the firearm in a place to which a person knew or should have known that the child would gain access to it. Okay, if you know that the child has the code to the gun safe, right, then that makes the gun safe virtually useless.
But then how does one protect themselves, God forbid, in an emergency? You hear stories like this with a child. There was one story in particular where the child called up the parent to say, is it okay if I get a gun? And under those circumstances, he said, yeah, go get it. But what if there's no access to the parent and the child's smart enough to know, hey, I need to defend myself and I'm going to somehow break in. If it's a steel safe, you don't have a
Again, you're going to have a defense. If it's to defend themselves or even some kind of a believed justification, there's going to be that defense.
Okay, here's another thing.
Okay.
If I was an attorney, I would come up with this. I would say, okay, you think the gun is secure, but you got in one of these Walmart wooden gun cases with the particle board backing that has staples holding it in there with a little tiny lock in the front and a glass pane. A child could get a screwdriver, pry open the backside without a problem at all, and take a gun out. In the eyes of the court, is that a secured weapon?
You could have that kind of raises another issue. So a 2 or 3 even maybe. So really the standards to secure means take steps that a reasonable person would take to prevent access to a readily dischargeable firearm by a child. Okay, including but not limited placing a firearm in a locked container.
So I guess it would be determined. The parent would have to make the judgment how.
I think in that situation, when you have a child busting, breaking down a safe and busting into it and breaking into it, right? That's.
Well, no, I think there's a difference because say you got a toddler and you know that the Walmart cabinet is adequate to get the job done. But all of a sudden your toddler becomes a teenager, a young teenager, and has the smarts and maybe the will and desire to get into that Walmart showcase isn't really going to be secure enough.
But do you see how the answer to this question depends on the facts?
Yes.
It's a fact question, which is always dangerous.
Clarify.
And so, because if you're charged, you're going to be having to ask a jury, right, to decide this fact question.
Okay.
Fact questions go to the jury. And so you don't want to be having to ask 12 people to decide this fact question when they don't know your kid, they don't know the circumstances. They're trying to look at it from 3 or 4 different points of view.
Do you realize, to me, that sounds backwards? The fact question has to go to the jury. You would think the fact question would not have to be analyzed. It's like, this is what happened, this is the result. As compared to a gray area that the jury deems like, we reasonably believe that person was correct, or we reasonably believe that person made a misjudgment. So it's kind of confusing, the terminology.
Right, and the standard for criminal negligence itself is a confusing term, okay? So I'm not even going to read that because it would just confuse everybody, okay? So we're going on the fact of, do we think that this was reasonable, okay, for today's purposes? Do we think this was a reasonable decision about what to do? But you also have this defense, okay, when there was an illegal entry. An entry that was illegal under the code. So if it was
illegal, somebody's coming in the house and you got to protect yourself, or an illegal entry of the child getting access to the gun, which one?
Could you make an argument that your child committed theft by breaking into your safe when you've not given him consent to do so?
And there's no emergency. Or if there is emergency too.
I think that you can raise that issue.
Okay.
I would if I was a defense attorney.
Ladies
but again,
you
don't want this situation.
The reason we split hairs, the reason I split hairs, is because I know that they can be split in the courtroom. I know. I've been experienced with law in the courtroom. My dad, my grandparents, my brothers, the whole works. I'm inundated with this thought process of winning, spinning to winning, okay? And so whenever I come up with a situation, I've got to think 3 steps ahead of myself before the situation ever happens, because I know if the situation does happen, I've got high-powered attorneys out there who want to win a case and make their name big, and they're going to do whatever they can to spin it on me. So I've got to do the lower hemisphere and spin the opposite way.
And so look, a lot of times there's no good answer to these questions, but if you leave the firearm on the desk like this and you leave the magazine right next to it, you haven't violated this statute, in my opinion. And I'm reading the language of the statute, and it's not readily dischargeable if it's not loaded, okay, at all.
I'll tell you why I'm very picky on this, Ross. What you just showed me, people can't see what he just did, but he mocked putting a pistol on the table and the magazine is out separate from it. And it's obvious, because if you read the black and white law, that is not a violation. But the problem I have is I go to instructor school, I get a 33-year DPS veteran talking about signage, Penal Code 30.6 and 30.7, and he talks about, those Ghostbuster signs, a circle with a slash in it. If somebody's got it on the front door, you know what they mean. Don't go in. And I'm like going through the roof. The signage for keeping people out is one of the most basic things. It has to say this. Because if it doesn't say that, I, as the license to carry holder, don't have to worry about it. So when you have that attitude of getting a black and white thing and turning it into gray, I've got to worry about every other thing in the law that's black and white being turned into gray in the courtroom.
Again, I go back to, it's not readily dischargeable. That's all I can say. I mean, you're preaching to the choir. Okay, so if it's not loaded at all, there's not one in the chamber, there's nothing loaded at all, it's not readily dischargeable.
Well, Ross, in your experience,
it's got to be readily dischargeable.
In your experience, if you're the choir and you're going into court to try to explain that to the jury, how often, in your opinion, or have you experienced it?
If you want to look at it that way, let me
finish the question for the audience. How many times in your experience have you seen a black and white law get totally disregarded because of opinion? And okay, that's what I thought.
I mean, I had a 3-hour argument about 4 weeks ago on a statute that I thought was absolutely crystal clear. I ended up winning, but I almost felt like a bad lawyer. I almost felt like, why did it take me 3 hours to convince the judge of this?
I know where you're coming from.
And the other side, he was a great lawyer, great talker. I mean, he's a great lawyer. I mean, at the end of the day, there was really no argument I could make other than, Judge, the words say what they say.
I'll tell you what the difference is. I've known you for a while now. I can tell your heart. Your heart is true to get it for the person who's in the right to not get screwed. But you got others out there who are doing it to make a name and make a buck. And so it all depends on your attitude going to the courtroom is why this person who you debated for 3 hours probably knew you were 100% right, but he says, I got an angle here. I can do this. I'm telling you, that's what people think.
And so that's what I'm telling you. You need to be careful. I think, and it's going to be, too, like we talked about, it's going to be all circumstance-based, okay? And so we is leaving on your nightstand while you're sleeping in the house, ready in case somebody comes in, reasonable under the circumstances? I mean, under many situations, I think it probably will be, but I'm not going to tell you that because I don't know the facts. And you're going to be asking a jury to decide those facts if something like this happens, potentially. Now, these cases a lot of times don't get prosecuted because prosecutors understand that bad things happen, and it's also a proof problem. Who knows whether it was readily dischargeable or not. Okay, I think if this kind of situation happens, right, I'll be very careful about what you say to police. Okay, and
always, man, they're just a recording. They're a recording device. Be careful what you say.
I do want to talk about at least one more thing I thought was kind of cool in this statute, and it deals with one of these defenses. And one of these defenses says, okay, that if the child's access to the firearm occurred during a time when the actor was engaged in an agricultural enterprise. As you notice, this doesn't say supervised by an 18-year-old and was for hunting, sporting, and other lawful purposes. Yep. You'll also see that this word say actor. So we're talking about the parent or the adult or the whoever it is that gave access to the child, because this is the suspect. This is the person. The actor is the one we're charging. Okay, so it says the child's access to the firearm occurred during a time when the actor was engaged in an agricultural enterprise. Agriculture means floriculture, means growing flowers, livestock, crops, poultry, forestry, wine. Anything that deal with outside like that is going to be agricultural enterprise.
And why would it be necessary? Snakes, hogs, things of that nature?
What I'm saying is I don't even know what this is really going to... I don't know how broad we can take this.
My general opinion of it would be you've got a young lad there doing work for dad, and here son, take this just in case you see a snake or there's a hog destroying crops, blah, blah, blah.
That's the way I take it, but the actor, not the child.
I'm confused on that. Clarify.
The actor would be the defendant.
Okay, gotcha.
So it would be, in your scenario, the parent.
Yeah.
Was the parent engaged in an agricultural enterprise?
To some degree, because he has hired someone, quote unquote.
Or did the legislature mean what you said? Did it mess up and put actor when it really meant the child?
That's what the jury would decide, wouldn't it?
That would be a question of law. And so,
is that a question of fact?
That's a question of law, right? What the interpretation of that word means was going to be up to some judge somewhere. And I think the key words in this case may even hinge on engaged in. Was the parent who ever actually engaged at the time that this happened? Were they engaged?
We're not talking marriage either.
And did you know? So even under the finance code, right, and under the tax codes, agricultural enterprise can be financially related.
And in this neck of the woods, this is very important to know. Because, I mean,
Exactly.
how many people do you know working a tractor that are under 18
And
years?
so was the legislature really trying to give protection to farmers and agricultural folks out there because of exactly the reason you said? Because sometimes dad and son go out, one gets on this tractor, another gets on this tractor, goes into this field and this field. Son takes a shotgun, dad takes a shotgun or rifle, and if something happens, they don't want dad getting in trouble because that those are necessary
Well,
parts.
sidebar note. I heard this one time. I don't know if it might be in a different state or not. Is there any regulation or legality about having a person under 18 years of age riding tractor equipment?
Lifeline, Rick God.
I don't know. That's why it was a sidebar. Okay,
I'm
look,
sure other
we're
people
running
know
out,
the
we're running
answer
out
to
of
that question.
time.
Call
Let's
and
go.
tell
Let's
me.
go to this negligent and accidental discharges. Off the top of your head, I know I threw this on you. Can you explain the two? Because I can. I just want to see if you have a legal aspect of it.
You want me to explain like in a hypothetical?
Yeah, hypothetical. Because I've got actualities.
Okay, so a person. Oh man, what's the one where you had? You go ahead, because I'm going
I'll
to say the
explain.
same example that you're going to say.
I'll explain.
I'm going to say the same one you're going to say.
I had two situations happen to me. Okay, I'm extremely cautious with what I do, constantly to the point of almost to a fault. Okay, constantly check, multiple times checking. But here's what happens: there's negligent discharge, accidental discharge. Example number one: accidental discharge. I'm working a handgun, doing it in the step-by-step manner that you're supposed to handle it when loading it. Okay, this happened to be a PA-63 in .380 caliber. It's got a decocking mechanism. It's a double-action handgun. The magazine goes in. The slide is racked. When you rack the slide, the hammer's cocked. Okay, finger off the trigger, pointed in a safe direction. The decocking mechanism is pushed down to release the hammer, but not strike the firing pin. A mechanical mishap in the gun, worn out parts, caused the gun, even when dropping the disconnector, the decocker, caused the gun to fire. I did absolutely nothing wrong. I had an accidental discharge because of a mechanical failure unknown to me. Negligence would be, I'm running around one in the chamber, the gun's off safe, okay? I didn't have this, don't misunderstand, but I'm going to explain the difference with the negligent. Negligent is where you, the gun is loaded, the safety's off, your finger's on the trigger, you're running around and you hit a bump and you pull the trigger. You should have known the weapon should have been on safe, either not chambered, don't put your finger on the trigger. That's negligence. You're doing it wrong, okay?
I think a good attorney would argue that the second scenario is reckless, and that even though it may have been an accidental discharge, it would have been negligent if you were pointing the weapon in a wrong direction.
Well, true, yeah, you always don't want to point at anything you're not...
And so even though that would have been a mechanical failure, right, it could still be negligence, right, depending on where you were pointing the weapon.
That's true.
What you were doing with the weapon at the time that the mechanical failure happened. Just because the mechanical failure was an accident, you would have known, a reasonable person would have known that this is a deadly weapon, right?
Don't
At
point
all
it to the
times,
other shit,
anything could happen. You need to point it down. I'm not saying that that would be the case. I'm just saying I could see a good lawyer saying that. Okay? And, you know, again, fact question.
Okay.
Does that make sense?
Yeah.
And it is. Sometimes it's a hard question to determine whether it's really an accident or whether it was negligent. And that's what I'm saying. That's why you need to make sure that you're trained in how to use your firearm. You need to make sure that you're careful in how you use it. And two, what if you got an office? Here's the thing that scares me, right? I got weapons in my office, right? Mainly because it's my home office. And so if somebody breaks in, I want to be able to protect myself.
Right.
Well, I get family law clients all the time. What if I get some snotty-nosed kid, my parents and I go back to the back to estate planning, and I didn't know a kid came in, maybe my secretary went to the bathroom for a second, and this kid goes roaring around and finds a weapon in my office. Mm-hmm. Okay, and so I'm paranoid about that. I try to make sure that,
Well, the problem
that
with
we
you
know where
is-
these kids are the whole time.
The problem with you and me is we're put on higher standards because of the positions we hold.
I don't know that we are legally speaking, but I think socially, I think that
Yeah.
somebody, would
You should have
come.
known, yeah.
Yeah, and so somebody would probably say something like that.
That's why I'm always saying I'm always trying to be 3 steps ahead because I know how they're going to spin it back on me. Even though it's an accident. Accidents happen. But I should, because in the position I'm in, anticipate 1 to 2 or 3 accidents ahead. and try to avoid that potential problem.
And so, especially in today's world, you're going to have all the wolves coming after you.
That's right. All right, look, Ross, we're on the clock right now. So look, we're sponsored. This segment's sponsored by Coupling Dodd Krebs Law Firm. We can't thank them enough. Rick, thank you very much for your continued support. And we have the awesome, great, extraordinary attorney Benton Watson here to assist as well with Rick Dodd. So tell them how they can get a hold of you, Ross.
And you can get a hold of me at 105 East Main Street here in Cameron, or call my office for an appointment in Houston, College Station, anywhere in Central Texas at 254-605-4140. That's 254-605-4140. Again, we love talking to folks. We get questions all the time. And so feel free to email me, because we love talking about the issues and maybe getting the word out even to the legislature. Email me at benton@watson.legal. That's Benton, BENTON, @watson.legal, no .com. But make sure if you do email me, leave your phone number, because sometimes I can't email back. I just want to stress that.
I'm getting a lot of comments on this segment, and all the segments, actually, the whole show in its entirety. But they like the interaction and the information, and then also the YouTube videos, so that they can go back and look at it over and over again and take notes. So I just want you to know that a lot of people are appreciating